Good afternoon, everyone, and thank you for joining us. As I'm sure you know, the process by which Afghan nationals can request humanitarian parole if they're not at the border has been marred by inconsistencies and significant delays. From pretty much the moment the U.S. withdrew from Afghanistan, USCIS, the agency in charge of adjudicating humanitarian parole requests, was woefully unprepared to handle the thousands of applications they received. And today we've gathered a group of panelists who can help us sort through, one, what is happening in the agency with regards to guidance to officers on how to approve HP applications, the trends we're seeing in adjudications, and where is humanitarian parole going in general as it gets talked about in Congress for potential changes. Fantastic panel of experts today. Leila Ayoub, co-founder and co-director of the immigration attorney at Project ANAR. Belinda Liu is also an immigration attorney and a pro bono director at Project ANAR. She focuses on providing technical assistance in developing ANAR's high-touch pro se model of legal assistance to maximize the capacity of legal service providers and pro bono attorneys to meet the needs of newly arrived Afghans. They've done hundreds of applications and helped hundreds of folks who are in this situation. With us is also Stephen Pellet, the Legal Knowledge and Training Director at the International Refugee Assistance Project. And last, but certainly not least, my friend, Adriel Orozco, Senior Policy Counsel at the American Immigration Council. We'll have 10 minutes or so to get to some questions at the end, and the panelists will be addressing some questions additionally in the chat as we go through the materials. Please use the Q&A feature at the bottom of your screen. We'll be looking at questions through those methods, and I will be asking them of our panelists at the end. We'll also be recording this discussion and sharing it with folks who registered via email. With all of those housekeeping items in mind, let's get right to it. Steve, I think you're going to be leading us off today. Tell us what's going on with humanitarian parole at the agency level. What is the agency telling adjudicators about what they should be doing with these applications?
Thanks so much, Raul. Thanks so much to the AIC for hosting it, and I'm really excited to be joining everyone, and thanks to the folks, Leila and Belinda at Project ANAR, that have done so much work organizing and working on these applications. And so I'm going to be talking a little bit about humanitarian parole and the new USCIS training and guidance documents that are covered in the practice advisory that Project ANAR and IRAP put together. And so my sort of objective today in the about 15 minutes that I'll be walking through is that legal practitioners, and this is sort of obviously a presentation that we've, are designing for a legal practitioner audience. And so there are other resources that exist for applicants, and IRAP has some on our legal information website that we're updating, and I'll mention other resources at the end. But that legal practitioners have the background to use IRAP and Project ANAR's practice advisory that is on IRAP's website now, and you can access, and also are able to access USCIS's humanitarian and significant public benefit parole guidance training, including a memo that USCIS wrote related to Afghan adjudications and other HP documents. Those are all linked and available through our practice advisory. And so what I'll be covering today is some brief background on USCIS humanitarian parole applications to sort of give some context and shared language and make sure we're on the same page, and then some explanation of key changes in the 2022 guidance that has now just been released and obtained through this Freedom of Information Act request, and then sort of conclude with some tips for practitioners, and sort of basically walking through this advisory that we have put together. And so, some quick basic background and grounding. Humanitarian and significant public benefit parole will often just refer to humanitarian parole, or HP, but the significant public benefit component is also there in the adjudications. And we're dealing with applications to USCIS. And so, parole is a discretionary permission to enter the US. It's based on urgent humanitarian reasons or a significant public benefit. It is a temporary permission, but allows for permanent options. Individuals who receive parole may apply to adjust status or apply for asylum if they enter the US. Part of the framing of parole and USCIS's guidance is that it's not intended to circumvent or bypass other visa or refugee processes. And individuals who are outside of the US, not at a port of entry, can apply to USCIS using Form I-131. They can apply themselves or be the beneficiary of an application that someone else files. And as part of the process, a sponsor is required, and usually that is documented through an I-134 form or an organizational letter. And continuing with some of the background here, the law that relates to this derives from the INA, Immigration and Nationality Act 212D5, which authorizes DHS to parole individuals on a case-by-case basis for urgent humanitarian reasons or significant public benefit. And those terms are going to be, sort of explained and sort of codified in the guidance that was released and is helpful for practitioners. And this website is on individual humanitarian parole applications to USCIS. We're not covering other parts of parole that derive from the same part of the INA. We're not covering parole at ports of entry by CBP or ICE parole from detention, or the special programs that are administered by DHS, just to list some alphabet soup, the CAM, U4U, CHNV, or other programs. And we're also not covering sort of when a US government agency puts in a direct request to USCIS, or reparole for folks who are here and are in parole and then are applying to sort of extend their parole, which is referred to as reparole. So those are sort of different processes. So just, as a grounding to make sure that we're talking about the same things and what these documents are helpful for. And so some grounding on the process as background, which will sort of help situate the documents and the changes. Humanitarian parole to USCIS done by filing a form I-131 and 131, which is mailed to the lockbox on the USCIS website address or filed online. If you're filing online, you can't file a fee waiver request, but folks can file it online now. There's an optional fee waiver that you can do with a form I-912 or with a fee waiver statement. And as I mentioned, the sponsorship aspect of the eligibility is usually addressed by attaching an I-134 form or an organizational letter. And so there are these filing aspects. Some of those are sort of addressed in the behind the scenes aspects in these standard operating procedures or SOPs that are part of the linked in the advisory, which may be helpful to folks. But a lot of the materials on guidance and training that are new relate to the adjudication by USCIS after if someone is filing a fee waiver, it's done by USCIS's sort of team at the lockbox, but then all humanitarian parole applications would go to the Humanitarian Affairs Bureau, or HAB, which adjudicates the form and really assesses the eligibility as well as the sponsorship documentation. They do issue sometimes requests for evidence, and those, when responding to those, the different materials that we've gotten through the Freedom of Information Act may be helpful. There's also, if USCIS either approves or in the case of Afghan cases, issues a notice of continued parole processing for those in Afghanistan, the overseas processing aspect happens after that. The guidance documents that we have relate less to that, which is done by the National Visa Center, coordinating with consular offices. People submit a form DS-160. They go through biometrics, medical exams, a very limited interview in most cases, and a then boarding foil issuance, hopefully. And so that is the more than 2-minute, but relatively quick overview of the process. I'm going to talk a little bit about eligibility, and I've highlighted where some of the documents and guidance materials that we have identified fit in. One of the documents that we have is actually a parole adjudication worksheet that's referenced in the practice advisory. That doesn't really give any new information, but it provides a helpful view of what adjudicators sort of literally the boxes that they check off when they're going through an application, and they're looking at whether someone has an urgent humanitarian reason or a significant public benefit articulated in the application, and then a bunch of discretionary considerations involving sponsorship, the temporary nature of the application, other immigration options that are available, whether they've complied with immigration laws in the past, security check results, and other discretionary factors. And really the training and guidance that we have will help practitioners understand how USCIS is approaching urgent humanitarian reasons, significant public benefit, and other discretionary factors. So if you're working on one of these on behalf of a client, you're going to want to know what is an urgent humanitarian reason or significant public benefit reason. These are not defined in regulations. It's not covered in USCIS's sort of public policy manual or the adjudicator's field manual that was public previously. What USCIS Humanitarian Affairs Bureau does use to adjudicate them are a parole training module. IRAP had previously filed a Freedom of Information Act request and received a 2017 copy that's been on our website for a while that has been helpful to understand a lot of the details. What we have now is the 2022 version of this, which has a bunch of changes to certain sections that I'll flag. The other things which are in the practice advisory, which as far as I know are newly public for the most part, the standard operating procedures, it's about 120 pages of sort of the behind the scenes aspects. And I should note that that training module really, according to USCIS, is the document, according to their SOPs, that provides substantive policy guidance on how to determine eligibility for parole. So it is a training, but it is really also their eligibility document and their guidance. And so that's why it's particularly significant if you're trying to tailor your application to exactly what standards USCIS adjudicators will be looking at. The other documents that we would expect them to look at, there's a memo on parole requests for Afghan nationals from October 2022 is the most recent version that we're aware of, and that lays out some additional strong positive factors that USCIS will consider, and I'll note those. The other documents that might be helpful for folks working on these, there is some templates and guidance, like a lot of samples that they use on requests for evidence. And so you can look at those and sort of anticipate the type of RFE that could be issued, and then make sure that you tailor your evidence to preempt that and avoid that sort of delay in process. And then the parole adjudication worksheet, I mentioned just sort of the checkbox. So you're tailoring, making it as easy as possible for the adjudicator to sort of approve your client's application. There are also a bunch of guidance on fee waivers, this SOPs for that, and the fee waiver training, which may be helpful for folks to make sure that you're getting a fee waiver whenever possible. IRAP often will apply for the individual overseas as the applicant, and go through, even though they have a sponsor separately in the US, we use the applicant's financial situation and have had some success with getting fee waivers, and would certainly not want to ever pay the extensive filing fee when the fee waiver is possible, particularly when there's a large family and each individual needs an application. So just moving right into the changes, what changed in 2022, the training module being dated in April and the Afghan memo being in October. We actually ran a informal compare doc that is linked in the memo that you can pull up and see line by line for the most part. Exactly what changed there is not the full exhaustive list. Our advisory is pretty lengthy, and then you have the compare doc to look yourself, and you can compare them side by side. The 2017 one is up, but there were substantial revisions to the targeted harm section, and that is relevant because targeted harm based on protection is such a important basis for many Afghan and other nationality applications, but numerically right now, Afghan applications are the largest. But you can also use this guidance, obviously, for any individual who you are helping file humanitarian parole for. And then the memo contains the documentation of various strong positive factors for Afghan cases. The outlines of these changes have been on USCIS's website. They've also been reported in at least one media article, but the criteria in the memo really provide you with like the full details, some additional context, and a direct citation of what the adjudicator will be looking at. And so they're important to highlight in that respect. Just going over eligibility, this is how the training module breaks down the different categories for a humanitarian parole request. And we would recommend you look at the module when you're filing one. Medical reasons, family-based request, protection-based requests, broken down into natural disasters, civil conflict, which has not, for various reasons, been the primary basis for consideration and filing, and then targeted harm. And that's where we've highlighted, because that's where the changes have happened. And overall, the changes have sort of expanded the possibility of receiving a grant, particularly for those who are applying due to targeted harm, due to membership in a risk group. And so just highlighting a couple of the changes, and in the advisory, there is a side-by-side table that you can look at, but some of the questions and things that have changed, really looking at, does a humanitarian parole applicant need to submit third-party evidence that they were individually targeted? In 2017, the memo, the training module notes that there must be credible third-party evidence, and it refers to evidence of threats to the applicant specifically. And in 2022, the version notes that other strong evidence may be possible, and then defines and gives some examples of other strong evidence that's in the full table that we have in the advisory. Can reliable country conditions support a claim of targeted harm? In 2017, the module says that at-risk group membership, if that's the basis, is generally insufficient. In 2022, country conditions can support a claim if there is evidence of widespread or pervasive systematic targeting of serious harm directed at a particular group, which is often the case for groups of Afghans. It also goes into what factors USCIS considers relevant in the exercise of discretion. There was some particularly concerning language that that when a case is based in 2017, the language was that when an application is based solely on targeted harm, an officer generally should exercise discretion to deny the request. And in 2022, that language is gone, and it says that some cases even where there isn't enough evidence to meet the overall targeted harm standard, if there are other strong positive factors, such as family unity or particular vulnerability, then the officer can exercise discretion to approve. And there's also some expansion of whether approval of asylum or a refugee grant or SIV grant would apply just to immediate family or to broader family members. And then the 2022 guidance, they use an example of a sibling as someone who could, as opposed to just immediate family. And so just going to the Afghan memo, there are a number of strong positive factors. These have been on the website for a while, but the memo includes also some consideration for more extended family members. And certainly you should be looking at USCIS's website of the strong positive factors and highlighting them, and can also look at the memo, which notes that there's a significant public benefit to help Afghan allies. And so, the key practitioner tips, just to wrap up, are really that, you want to be following and citing to the 2022 training module, highlighting particular vulnerabilities, citing to those findings of a significant public benefit, and really submitting any other evidence of, there is a lot more emphasis on risks to beneficiaries in third countries, which you would also want to be aware of and highlighting. And just to do a final wrap up, you can access all of these documents through the practice advisory that's on IRAP's website, and likely Project ANAR's as well. and then you want to be using USCIS's websites. They're also in Dari and Pashto. Project ANAR has resources that are in Dari and Pashto, as well as there are some other organizations that have sort of full humanitarian parole or parole guides. And then you can look to IRAP's legal info website that will be updated. There's a guide now that is accurate, but it'll have additional updates from these advisories to come. So now I'm going to pass it to Project ANAR.
Yeah, let's bring Leila into this conversation. Leila, you're the director of Project ANAR. You've handled hundreds, if not thousands, of these applications. Stephen just gave us a rundown of what is supposed to happen. What has actually happened? What are you actually seeing in practice?
Yeah, thank you. And again, Project ANAR, we came together in 2021 in response to this need. And our foundation is a pro bono project matching legal volunteers with folks who are finding themselves filing these humanitarian parole applications. And at that time, I mean, many folks here know, we can see from some of the questions in the Q&A box that for many Afghans in the US, either like on a practical level, when you're looking at the options available, or when you try to advocate for your family, you're directed towards this pathway still even today, 2.5 years later. It's one of the only options available to many people. And that's why we found ourselves filing these applications and on the scale that we were doing it. And so through our project directly, we have filed around 1,500 applications through our legal volunteers and internally. And we have been in touch with many practitioners throughout the last couple of years. And we will try to share this with folks afterwards also, but as you have seen, some of the information that we've gathered on this process has been through FOIA requests from reporters from other organizations on this call. And some of it has been directly from the government that has been kind of limited. And a lot of it has been anecdotally what we've been gathering from our clients, from the cases that we worked on, from other practitioners who reach out to us. So that's where this information is coming from. I just want to highlight big picture. I know Raul answered a question in the Q&A box with, or sorry, Adriel did, with some of the numbers that we've seen from USCIS on humanitarian parole. I will just share the latest that we heard in the end of January from USCIS, which seems pretty aligned with this, but just shows how limited the information that we have is still. So they said at that point that they had received over 53,300 Form I-131s and adjudicated 18,750 cases with 34,500 pending. So they didn't give the breakdown of adjudications, which makes it really hard to understand what the actual trends are. That number includes denials and conditional approvals, and it does not include administrative closures, though, because they don't consider that to be an adjudication. And it also includes all of the applications from some point in 2021. So it doesn't really tell us, again, like the timeline of adjudications, where what we saw in the early days post-August 2021 was different from what we're seeing now. So I'll just give kind of an overview of what it is that we have seen with adjudications. Many applications were filed between August and November of 2021. Prior to that, in the community, from legal practitioners, we had heard of approvals the summer of 2021. That's why another reason why many people pursued this pathway. And then when the embassy closed in Kabul, when the US withdrew, we saw like a pause on adjudications. And that was after many people had already filed their applications, had paid application fees. That is why we've seen that USCIS collected $20 million in application fees, because there was this time period where a lot of people were filing, they were expecting applications to get processed, and then suddenly they weren't. So many applications have been pending since fall 2021, and that's why it's hard to really give a sense of the adjudication timeline, because it just continues to increase the longer that applications remain pending. And we saw the government working in real time through how they're going to treat these applications. They kind of shared that they had to figure out a new way to process them because of the scale of the applications. And they were figuring out how to process them without the US embassy or consulate presence, although we know that there's many examples of other countries where there is also not a US presence, and there's ways that the government deals with those kinds of situations. So initially, we heard some of these policies, like Steve highlighted, the evidentiary requirements, which some of those have shifted throughout the last couple of years. We definitely feel that's directly in response to a lot of the pushback from advocates throughout the last couple of years. And we were having a lot of pressure on the government to process these applications because it was months that they were just frozen. And then around December 2021, January 2022, we saw a small trickle of adjudications, and the majority of those were denials. We were really only seeing denials at that time. So some of that FOIA data from Reveal News, from AIC and IRAP that came out last year and the year before, it showed that there were such a small fraction of applications adjudicated, and the majority of adjudications were denials at that time. The vast majority were denials. And that fit with what we were seeing from our cases. Many of us attorneys on our team had filed applications for our own families, and all of those were denied. And then we were really hearing from the government that they could not approve applications for people in Afghanistan at that time. So at that time, the trend was denials and then a number of administrative closures. We see that occasionally today still, in an administrative closure saying that this person may be eligible for parole, but we can't give them a conditional approval because they need to get themselves to a country where there is a consulate presence and they can complete the HP process. And we're gonna make the final decision on their case at that time. Since then, we have definitely seen a positive change that we are seeing conditional approvals for people who are still physically in Afghanistan. So then they can make that informed decision to get themselves to a third country where they can complete the process. And we have definitely seen an increase in approvals recently. But again, it's so hard to be able to properly advise people because of the limited information that we have. And we will hopefully be able to share this link with folks, but part of what we are doing is trying to collect that information in an organized way. So we have a survey for adjudications, which people can complete. Practitioners, pro se applicants, whoever can complete that form. It's anonymized for us to get some more information about what these adjudications have looked like. And yeah, so that's the general trend that we are seeing, that there are in-country, in Afghanistan, conditional approvals nowadays. We have still heard from USCIS, this is what they shared in public forums and engagements, that they, it's kind of hard to understand what the prioritization looks like. That's why that FOIA materials and everything that Steve shared is really helpful. But they have said that they still prioritize applications in third countries because those people can access consular processing and complete the process to reach the US. However, we don't necessarily see how that it translates to the adjudications because, like I said, we have seen in-country conditional approvals as well. They have told us as well that they always kind of consider whether to expedite applications. And the best thing that someone can do is to provide as much information as possible in applications about the urgency. And Belinda will go more into like some of the specifics on like a practical level of how we're continuing to work on applications. But a couple other quick things I wanted to highlight, the big picture trends that we have seen people reach the US with conditional approval, or sorry, with approved I-131s. And a lot of that does track with the priorities and the special factors that are on the USCIS website. But some of it is a little bit outside of that. So we have seen the majority of the approvals that we have seen are people with some type of family in the US, not necessarily one of the relationships that's listed on a strong positive factor, but maybe someone in the family has one of those relationships and others have more extended family relationships. We have seen many for people with like SIV cases, I-130s, things like that. We are mindful that there's been other sort of policy changes, and I know Adriel will talk about this also, but even outside of like parole itself, people who were arriving on approved I-131s prior to last fall, they were eligible for resettlement benefits, and now they are not. That's because that was congressionally authorized. So those are just things that are impacting what the process is like for people who reach the US. On a last note, we definitely still see that like this scale of people coming to the US on approved I-131s it seems to be, I mean, we think that the certain excuses that we hear from the government are really not true. We know that they could be doing the things that we're asking for, but at the same time, I can definitely understand that this is a scale of things that they had not seen before. So it's we see that reflected in some of the response from the government and how they're not used to processing these types of applications necessarily. And so one thing that we have seen recently is that these applications are supposed to be approved for a 2-year period. Some people are arriving and they're getting a 1-year parole stamp one place and 2-year one place. So that's just something that we flag to attorneys as well, and to community members that that's something that they can get changed because it seems to be a mistake.
Leila, before we turn it over to Belinda, just wanted to, there's a lot of chatter right now in the Q&A box about sort of giving us the timeline. In about a minute, can you tell us, like, is it just too undetermined right now to tell folks, hey, it's taking 6 months or it's taking 3 months, or can you discern a trend from what you're seeing?
Yeah, so I can share this, that the adjudications that we are seeing are for applications that have been pending since fall 2021. So it's been 2.5 years for those applications. I don't know if we have seen, I can't recall. Again, we don't have the whole picture, but I can't recall from our cases adjudications on recently filed applications. Maybe other people have seen that, but it definitely seems like they're still working through those applications. So it just continues to increase the adjudication time. That being said, we always encourage highlighting any particularly urgent circumstances. The like historically stereotypical HP case was like certain like medical needs or reaching a loved one who is dying in the US, things like that. And it's possible that those cases could get adjudicated more quickly, but we really don't know.
So let's bring in Belinda now, and just to talk more specifically about those applications that are being processed. What are you seeing as in terms of further evidence that they're requesting, or any other trends about? Are you seeing a lot of administrative closures, and why?
Thanks, Raul. Yeah, that's a really great question to segue into this section of our time together, actually, because I am generally the one at Project ANAR who sees the adjudications or the questions that come in from our pro bonos. As Leila mentioned, our project, started as and continues to be really a volunteer-fueled effort. And the only reason we've been able to touch so many applications, thousands of applications, is through our hundreds of volunteers. So a lot of the progress that we are, that we're aware of taking place on cases is reported to us from the volunteers, since they're the ones who prepared and filed the applications. And what I can say just from the last year and a half is that the approvals that we're seeing are primarily for applications that have been pending since fall of 2021. There are some, there are a handful that I've seen that were filed in 2023 and approved, but those are almost all newborns, children who had to be added to cases that were filed in 2021 or in early 2022. And so, they don't really, you're not usually worried about a newborn having materially supported acts of terrorism or anything like that. So those tend to go through pretty quickly. And from our own actual direct casework, we just received a batch of approvals for family cases that were filed in fall of 2021, but went through 2 rounds of RFEs. So I think that also, plays into the timeline, how complex, I guess, the case is, if the beneficiaries have, military ties or government ties or something that would cause the government to, do an extra round of vetting. So for more straightforward cases, I guess, where someone hasn't ever worked, I'm thinking maybe like a 15-year-old girl, something like that. Those we would expect to see decisions a little sooner on those. Now, and then in terms of what kinds of decisions you can actually get, so there are 3 types of decisions you can broadly you can get. One is a notice of continued parole processing. That's what we used to see for individuals who are in Afghanistan. Basically says that if you're able to get into an eligible third country, then you would be able to continue processing for parole. But if but for as long as you're in Afghanistan, there's nothing you can really do to move your case forward. So if you have a beneficiary in that position, then they would need to find a way to make it to a third country with a U.S. diplomatic presence. And then once they've made it to that third country, then they need to send an email to Humanitarian Parole at USCIS.dhs.gov. We'll put it in the chat or in the materials with the subject line, beneficiary relocated outside Afghanistan, with the updated address. And that will cause USCIS to basically ping that post to open a file at that post so that they can send out the information about medical exams and everything else. So that's how the consular process gets initiated at the post. Okay, so that's one way or one type of decision you could get. The other is a conditional approval, which is exactly what it sounds like. It's an approval that's contingent on passing the medical exam and also the interview. And so for conditional approvals, someone has to be in a third country already, a third country with a U.S. diplomatic presence. And then the third category, I guess, of decisions you could get is the denial. And officially, there's no real appeal from a denial of HP, but in some cases, you can resubmit the application with new evidence within a certain period, and the denial notice should specify what that period is and where you should send the information. On that note, you could also receive sort of not final decisions in the form of an RFE or a NOID, a notice of intent to deny. So for RFEs, we're seeing 3 general categories of RFEs. There are RFEs requesting information about, harm, the specific harm or fear that the beneficiary is facing, and also, steps that they've taken to seek protection under the U.S. Refugee Admissions Program or, UNHCR. And these all get to the protection question that or the protection criterion, I guess, that Steve had gone over in his section. And then we're also seeing RFEs issued regarding family relationships to the petitioner. So if the petitioner is petitioning for beneficiaries who are siblings, for instance, then we're seeing a lot of RFEs asking for proof of the sibling relationship. And then lastly, we are also seeing a lot of RFEs just asking for I-134s. So in the early stages of this whole, this HP flurry, in August 2021, and in the fall, a lot of HP applications or I-131s were being filed without the accompanying I-134s. And for a while, USCIS was receipting applications like that. So they were issuing receipt notices and beginning to process applications like that. Somewhere down the line in 2022, they would reject applications that did not contain an I-134. But again, we're looking at applications that were filed back in 2021. Those are the applications that USCIS seems to be processing right now. And so a lot of the RFEs we're seeing are, requesting I-134s, since if none has been filed before, and sometimes we'll be requesting updated financial information to supplement previously filed I-134s. Okay, so on to consular processing. So to note, one good thing to note is that the State Department has authorized and encouraged all posts, so all consulates and embassies, to process and accept Afghan HP cases. So in theory, an Afghan HP applicant or beneficiary could finish processing anywhere in the world with a U.S. diplomatic presence, in theory, if they could get there, of course. So the steps in consular processing, first you'll receive the conditional approval notice, which usually specifies the period of time within which the processing must be completed. It's usually about 2 months. And then there's a medical exam, and the assigned post will send the beneficiary specific instructions about, who to call at which, medical office to schedule the exam. So that's not research that the beneficiary needs to do on their own. And it's honestly not something that they could initiate on their own. They need to be invited basically by the consulate to start that process. And then there's the DS-16 or DS-160, which is the non-immigrant visa application that you can fill out online. And after that, there is the interview, the consular interview, and the post will schedule this after the medical exams are done, usually. And then final step is to return to the post to receive your travel document, usually a passport, with the boarding foil stamped in it. And boarding foil is kind of like a visa, but it's not really, because it just allows you to kind of enter the United States for this amount of time specified in your grant of parole, but you can't really do anything else with it. Okay, so those are the steps for processing. Now, what do actual timelines look like on the ground? The most data we have is for processing timelines in Islamabad, because Pakistan is just the easiest place for Afghans to get to right now, with a U.S. diplomatic presence, since they can't process in Iran. So in the last couple of months in Islamabad, we're seeing interviews being scheduled within about a month of submitting the DS-160s. And then the boarding foils are being issued about 1 to 2 weeks after the interview. And this is assuming that, nothing comes up in the medical exam that would, prevent somebody from entering the United States. For instance, if they get like a positive TB test or something like that, that can delay processing by a couple of months, while the beneficiary is undergoing observation and takes the test again. So that's what those timelines look like. And then once you get your boarding foil, the boarding foil itself will have a very limited window of time in which the holder can leave or can enter the United States. I think it's about a month, slightly maybe less than a month. So it's a pretty narrow window. And I think there's a question in the chat about whether you can get an extension of the approval of the boarding foil. And in theory, it is possible. You would need to email the post directly stating, why you need the extension, and you do need to provide some kind of justification. So, if it's like an injury, or, maybe you're waiting for like a family member, a minor, someone who can't travel by themselves and they haven't finished processing, and you really need to be able to travel together, because the other person can't travel on their own, that could be a good reason. I will say the posts are not known for being generous, with respect to situations like these. At most, they might allow, one person to stay behind, kind of thing. And so we would encourage people not to hold out, for approval for extensions for an entire family, and, just kind of move the people that you can move, out of to the United States when you can, and then leave, whoever can afford to stay behind. But it's quite unlikely that the post would grant an extension for an entire family, unless, again, there's like a very compelling reason.
So switching gears a little bit, and I want to go to Adriel to tell us a little bit about what's going on in Congress, and that's always it's always a dangerous topic, but and we don't want to read some tea leaves here, but what have you been hearing? What is going on? We know that HP was one of the things that was being sort of talked about being negotiated. Where are we now?
Great. Thanks, Raul. Thanks, everyone. Adriel Orozco, I use he and they pronouns. And I'm just going to go quickly because I know that it's really important to make sure that folks who have answered those questions can get them answered. I know that we've been hearing about parole much more often in the media, and particularly given some of the administration's use of parole, which has been more broadly used than other presidents in the past. It's always been used in particular situations around post-war evacuations, for example, in like the Vietnam War and the Iraq War. But we've actually been seeing it more targeted because of the broader programs like the CHNV program or the United for Ukraine program. And so given this broader use of parole, we've seen some senators, particularly Republican senators, try to limit the use of parole to particular circumstances. So there is a bill by Senator Chuck Grassley, which has been filed in the last two Congresses, as well as another bill by Senator Cotton from Arkansas that was added on to an Afghan Adjustment Act type bill, which was a bill that would have also allowed a path to legalization for some Afghans, to really limit the parole authority of the president to what is essentially a list of circumstances. Ironically, would have actually limited the ability for the president to use it in these types of circumstances to resettle individuals after a conflict that the U.S. was directly involved in. In addition, as I'm sure some people were aware about, is that about 4 months of negotiations between Republicans, Democrats, and the White House led to a border bill that ultimately was not passed in the Senate, which died in February, but that would have also modified parole authority. It wouldn't have impacted programs like CHNV or the Ukraine program, or even the initial Afghan evacuation program, but it would have largely prohibited migrants who were arriving at the border from being able to be paroled in, and it required a mandatory detention and being processed through more resource programs through that border deal, or through a new process that was being established through that bipartisan bill. I think more specifically and relevant to Afghan parolees, I kind of alluded to this as well, but there is a bipartisan bill that just focuses on a pathway to citizenship for Afghan parolees. It is sponsored by Senator Klobuchar and Senator Moran, as well as 4 additional Republicans and 4 additional Democrats as initial co-sponsors, but actually has 17 in total. It's called the Afghan Adjustment Act. It's growing in bipartisanship. Actually, right now it has more. It has 9 Republicans who have signed on, 6 Democrats and 2 independents. So I think that there is a growing recognition that even folks who are being allowed to be paroled temporarily, because parole is just a temporary status, do need some type of resolution and stability. And so, of course, I think the difficulty here is trying to see if something like that can move, given the hyperpartisanship in our Congress and in politics generally. And as Leila had mentioned, in 2022, through the appropriations process, Afghans were approved for resettlement benefits, which include being able to apply for benefits like TANF and food stamps. But that ended at the end of the last fiscal year, which was September 30th, 2023. Given that the federal government, or Congress in particular, has been extending fiscal year 2024 funding negotiations over and over again. I think the fourth time is expected this week. We haven't seen that included in those extensions. And so unfortunately, individuals who are paroled after September 30th, 2023 are not eligible for those benefits. And then just quickly, there's some lawsuits around parole as well. I won't really get into the details of those, but if anybody has any questions, happy to answer that either in the chat or afterward. I'll pass it back to you, Raul.
Adriel, thank you so much. And the questions have been coming in fast and furious, and unfortunately won't be able to get to all of them. But I wanted to see if I can pick out some trends here and there and ask you all. So I'm going to start with this question because I thought it was very interesting. Not that the others aren't interesting, but you get my drift. And I'm going to go to Steve for this one. What is happening to folks that are coming in, get the parole, get to the United States? What happens to them? Are they going through a CFI process? Are they applying for asylum? What can you tell us about that?
Well, if individuals receive humanitarian parole abroad and get a boarding foil and come to the US, they would have parole when they enter, and then they would, it would depend, sort of on their individual circumstances and consulting with the immigration attorney if they apply for asylum, or if some people may have family members who can sponsor them and go through the family-based immigration process. And then individuals who, it is possible sometimes individuals apply for re-parole because those processes haven't happened. And so, again, the process is meant to be temporary, but you can pursue those various processes. Obviously, lots of Afghans who are applying based on targeted harm would likely, consider applying for asylum, but that's like, obviously it's a specific decision on the facts.
Thank you for that information. I think that was super useful. And while you mentioned targeted harm, I want to stay on that as well, and maybe bring in Belinda and Leila as well on this. So let's say that you have a family that is still in Afghanistan that has suffered some targeted harm, and you have one family member that has happened to. Can all the other members then sort of in almost like in an asylum way benefit from that particular individual being a victim of targeted harm? What do you think?
I can start because I've seen like several questions around this, and then I'll let Belinda share some of the more the experiences that she has seen with these adjudications. But just generally, we have seen that most of the cases that have been adjudicated still tend to be people who fall into one of those categories of people who certain family relationships, SIV cases at certain stages of the process, things like that, that are strong positive factors for USCIS. So generally, we still see that they are not using this in a large scale as a pathway for people who are seeking protection, and still encourage people to pursue refugee pathways or other types of pathways generally. However, we have seen a number of approvals, and I'm seeing some examples in the Q&A box of cases where the main factors that people applied based on were targeted harm. And I have definitely seen that in some of those cases. For example, like one person in the family had a certain job that put them at risk, that other people also received approvals. But we've seen other cases where they are not getting approvals, and there's mixed decisions within one family. And the last thing that I'll add to that is, I know we may have mentioned this a little bit, but for the HP process, this is an individual application. There's no derivative benefits like as part of the process, and many of the families that have applied, again, reflective of the fact that this is the option this is really a last resort option for people who don't have access to something else generally. So the families, what we view as a family in our communities, what we apply for, like who we apply for, oftentimes are extended families, or it's like a grandparent, a sibling, and that's not someone who the immigration system views as a family unit. And then on top of that, there's no derivative benefits. But I'll let Belinda add other thoughts on that.
Yeah, so the short answer is yes. If only one member of the family, has received targeted threats, for instance, that can certainly be the basis for humanitarian parole requests for other members of the family. And then I would just make it very clear in your statement, because every HP application must be accompanied by like an affidavit of harm, they call it, or a statement regarding the circumstances that justify the expedited request and describing the humanitarian emergency. So in that statement, just make it very clear, my husband worked as, in the Attorney General's Office of Afghanistan in the terrorism unit prosecuting Taliban members, basically, right? And he had to travel around in like an armored car, and they know where we live, and the Taliban, engages in, will target family members to punish their enemies. And, if you are affiliated, if you're connected to anybody who worked for the previous government or for a Western government-backed project, then you are seen as, an enemy of the Taliban. And then in your country conditions, which you should also submit with your I-131, make sure you're including appropriate country conditions articles that show that the Taliban targets entire families as a form of collective punishment. And those kinds of articles are widely available.
Thank you, Belinda. This question is for the group. We only have about a couple of minutes left, but one of the things that we saw when we were doing FOIA processing was the implementation of a requirement of vaccinations. That was, when COVID was still going rampant and still happening, but obviously there were different requirements. What do you all know about the medical exams and those requirements?
So I'm not sure exactly which which questions are asked in the medical exam, but the medical exam is, for the medical exam, you go and you see a physician who's been pre-vetted by DOS, and they have a form that they fill out. I think it's the I-693, and you can find a copy of the form online. And basically, the medical provider just needs to answer all those questions. So I would use the form itself as the guide there.
But that's specific then, has been implemented specifically for Afghan humanitarian parole rather than other humanitarian parole programs. Am I getting that right or no?
No, I believe that I'm pretty sure that the medical exam is it's the same exam. I could be wrong. I haven't heard of a different separate one.
I thought there's other questions in about a minute or so. If situations have changed and an application has already been submitted, would you wait for an RFE or would you try to supplement the record somehow?
This is an excellent question, because I was just telling Layla that I forgot to mention this when I was speaking earlier. You should absolutely supplement as soon as possible. And there's two ways you can do this. So you can, if you have a USCIS account online and your application is linked to that, then you can just upload the additional evidence there. There's a special tab where you can submit additional evidence, but you can also email USCIS at USCIS or at humanitarian parole at USCIS@dhs.gov. And then you just have to specify the receipt number, the beneficiaries, date of birth and name, and then the petitioner's name, and then with all your additional information. So I would not wait for an RFE. And in fact, if you have additional evidence that falls into one of those new buckets outlined in the notice of policy change that came out last May, you should submit new evidence that's tied to the policy change, because we've heard from USCIS folks just at the last Afghan support center that we attended that that case officers were actually pulling cases that that were about to be decided, like pulling them to reevaluate them under the new criteria. So absolutely, if you have new facts or facts that fit under the new criteria, you should update as soon as possible.
Thanks for that answer. Folks, that is all the time we have for today. We hope you've found the program informative and enjoyed it. Thank you so much for watching. Thanks, Stephen, Layla, Belinda, Adriel. Thank you so much for being here today. Be on the lookout for an email with the recording. Have a wonderful afternoon.